Today, we're going to be going through the Tennessee contracts with the 2026 changes. And so I'm going to walk you through all of these changes through the different agreements. Now, I want you to know that I am a licensed broker here in the state of Tennessee, but I am not your broker. And so it's always important that you check with your broker on how they want you working through the transactions and how they want you utilizing these forms throughout your transactions. So let's get to it. We're going to be going over some of the 2026 changes along with the 101, which is your exclusive right to sell, 141 exclusive buyer's representation, and your purchase and sale agreement, which is the RF101. Now, this will include loan and inspection obligations, as well as notifications with the 656, timeline and performance dates that are very important that you don't miss, along with some of the disclosures. So let's get through it. Here are the changes for the 2026. There wasn't very many changes, and as you can see, the exclusive buyer's representation agreement is the first one that had similar changes across the correlating forms. What you're going to notice this year is that the 26 forms have selling broker changed over to buyer broker. All of the words across all of the forms from selling broker to buyer broker just goes in flow with a little bit of more of how we actually discuss who's listing with the listing broker and who's working with the buyer broker. Now we're going to have some changes in the purchase and sale agreement, the compensation agreement, additional contract language, received a couple new clauses, and then also a small change to that timeline checklist. And then the new form, compensation addendum or amendment, will go as well. That's going to be the RF620. And then there was a small change to the lease agreement for single family dwellings. Now, as a reminder, the version is always going to be 1/1/26 throughout the year until there might be a mid-year update, which typically comes out in July. So just make sure that you're always utilizing the most current version. Now, contracts require 5 things for them to be legally bound, so just make sure that it has legal purpose, the parties are competent, you have an agreement by an offer, and there's an acceptance. There's consideration, which not always is money, but typically is money, and then consent from the parties for the sale. Now, there are 2 documents that create your agency established in Tennessee, which is going to be the listing agreement and a buyer's representation agreement. And so if you don't have either one of these signed, then you're not accurately disclosing your status if you were to check that you had representation with this consumer. So make sure before you fill out your RF302, which is the confirmation of agency, that you have either document filled out before you check the box that says you're the designated agent for the consumer. So let's get right into this 101. This is your listing agreement. There are no changes for 26 on the listing. So very simply, you're going to include the brokerage name, where the seller lives currently, and then the property that needs to be sold. Just make sure that on the instrument number, you're using the deed information for the instrument. This is different than the parcel ID number found on the tax registry. Now, all the items listed here in A are going to be all the things that stay with the house. They automatically convey with the property. B is going to be anything else that the seller wants to leave for the buyer. C is anything they intend on keeping at the property that they're going to take with them. So it will not convey, meaning it's going to be removed from. And then any leased items, things like a propane tank, water softener systems. You might have solar panels. Anything that the consumer has signed an agreement to borrow and payments on, they'll fill this out. Now, if the leases are not assumable by the buyer, then the seller needs to understand that they are responsible to pay off the balance. You're going to place the listing price here, how much they've agreed to sell the property for, and then the effective date will be the day that you sign this agreement, and it will go through the expiration date. It's very important that you have a start and an end date to your agreement. This is actually one of the 21 ways you can lose your license in Tennessee. You must have a start and an end to these agreements. Now, down below, you do have a marketing of property commencement date. This would be if the seller has asked the broker to commence the marketing in a future date, meaning it'll be effective today and they're under the agreement, but they don't want the marketing to commence until maybe that honey-do list, photos, or similar things are taken care of, and the property will actually go active and available to the consumers in the future. A carryover clause is a number of days past the listing expiration date that a broker can still receive compensation for any party that was introduced to the property during the term that they have had the listing. Now, this carryover clause does not apply if the property is relisted with another real estate broker. Okay, at such time, the carryover goes away. Possession of the property could be date of deed, meaning we go to closing, we both sign paperwork, you provide the funds, I provide the keys. It gets recorded at the registrar's office. That's a date of deed. Now, date of deed plus would be that the seller needs a post-occupancy agreement to stay in the property after the closing. This would trigger the RF627. Now, you could have a situation where it's negotiable. Maybe the property is vacant, the seller doesn't live there anymore, and they would be okay with the buyer occupying to the closing. That would trigger the RF626 for the buyer to occupy early. Now, 5 just goes straight into the terms, the types of payments that the seller will accept. FHA, VA, conventional, USDA, owner financing, and many other types of opportunities. This is where you're going to place all of those terms that the seller will accept for this property. Now, number 6 was added in 24 during the mid-year changes right before the NAR settlement occurred. And this was just to put the sellers on notice that the buyers may request certain concessions to their offer. These concessions might include a home warranty, repairs, money maybe towards their buyer's expenses, and the buyer broker compensation may also be asked for. All concessions are purely negotiable through the PSA, which we call the purchase and sale agreement. Now, number 7 is simply put, there's a total compensation that the listing broker is going to request from the seller in order to pay for the services that they're going to render. This total could be just for the listing broker, or it could be an amount that the listing broker has already set in where they're going to share some of their total with the cooperative broker bringing the buyer. This total could just be the listing brokerage, and the cooperative compensation below could be 0. Or the total above could be a higher amount, and they're going to share some of their compensation, and that share would be listed here in the cooperative compensation section. Okay, again, this amount shall be taken from the agreed upon amount listed above from the total. When you utilize this sharing in this cooperative compensation, that triggers the form called the RF702. So make sure you're issuing this ahead of time. Now, there was a slight change to the 702 this year, where they changed everything from selling broker to buyer broker. Otherwise, the form still reads the same. There are 2 firms. One firm is agreeing to share some of their total with a secondary firm, also known as the buyer broker. Now, there could be a situation where this property is for sale, but it might also be up for lease. This could be at the same time as the listing. It could also be in the future when maybe the consumer has been on market a little while and it hasn't sold and they're feeling the pressure of the market. And so they would go ahead and place the property in property management as well. And whichever one happens first will supersede. And so should the property go in a lease rather than being sold, then the seller agrees to pay a total of an amount or a percent commission based upon the monthly rental amount. Okay, these things are very important to discuss with the seller consumer at the time of the listing appointment because it is more prevalent in our marketplace now than it was previously. Now, starting on line 76, we're going to go into what happens when there's a breach of contract, but also what happens when the seller wants to terminate their agreement with the brokerage. They can request that, but the seller does agree to pay all costs incurred to the broker for the marketing of the property, and that is known as a cancellation fee. Okay, the cancellation fee is going to be triggering the RF151, which is a listing mutual release agreement. This fee is determined at the time of the request of the cancellation. The reason for that is you don't know how long you've been marketing this property for, so you don't know what your actual marketing expenses are until the time of the request occurs. Now, there are some responsible parties that need to be listed here, just advising that the broker is authorized to advertise on the internet, the broker is permitted to file within the MLS, they're allowed to place the property in a place where other people can see it. Now, there might be an exemption or there might be a situation where a seller says they don't want it on blank. That means you would need to trigger a stipulation to state that that is going to be removed and it shall not be on those sites. Now, the broker is also authorized to place a sign and a lockbox on the property, and they're allowed to remove all other real estate signs. So if there's an expiration that occurs or a termination that occurs with another firm, the new firm is allowed to remove the old real estate signs to place their new sign in. This broker is also in a position where they need to provide the property condition disclosure or the exemption or the other disclosure form, as well as an MLS input sheet and the lead-based paint disclosure form to the seller. These forms are all in your 200 series. So the form numbers start with a 2. It will be the 201, 203, 204, and 209. Now, we also can have interior and exterior photos taken unless they ask us not to, audio recording, advertising this property, and so on and so forth. And the advertising is going to be how the broker deems appropriate. So when in doubt, check with your broker policies. Now, the seller shall also allow the property to be shown during reasonable hours. It's in your best interest to discuss with the seller what those reasonable hours are. Some people are morning birds and others are night owls. Check to see what's best for them. Now, Section 9 is just going to discuss the Foreign Investment Real Property Tax Act, which is known as FIRTA. In short, it's the seller's responsibility to talk to their tax advisors prior to the closing date regarding any tax matters and any potential taxes that they have to pay. 10 is going to be your hold harmless. It's the seller's responsibility to fill out the information regarding the condition of the property. If the seller is not aware of any defect or environmental factors or adverse facts concerning the property, then there's nothing really to disclose. But there's going to be oftentimes things that need to get disclosed. And so you're like, well, what is an adverse fact? Well, simply put, an adverse fact is going to be something that has an impact on the value of the real property. It reduces the structural integrity of the property, or it prevents a significant health risk to the occupants. A seller is also responsible for making sure that they check with their state and local laws regarding the video and audio recording devices being used in their house. We all know everybody loves watching that camera when the buyers come through the property, but it's the seller's responsibility to seek legal advice on what their limitations are on recording people as they come through the property. Furthermore, the seller gets to authorize the broker to host open houses and conduct showings. Now, open houses can be conducted by all the affiliated licensees within the firm. There is a new stipulation that has been added to the 707 that allows other firms to host open houses within this listing, should the brokers agree. We'll talk about that in just a little bit. Now, the second part to this that I've highlighted is very important. It's important for the seller to understand, although they may vacate the property, their insurance policy needs to be maintained. It needs to be kept in force just in case there's any damage, loss, or claims placed against the property during its vacancy. Once the property goes under contract and it's transferred to the new buyer's insurance policy will kick in, and at that point, they can terminate. The seller acknowledges and agrees that the broker can show the property to their own buyers. They are also not an expert in all the things. They owe no duties to the seller that are outside the Licensing Act, and they make all disclosures required by law and the National Association of Realtors Code of Ethics. Agents are not expert at all things. If the agent provides the consumer with information or about advice or assistance, the broker does not warranty or guarantee those services or products being obtained by the client. Meaning, if you have experts that you're providing to the consumer, it's best to place them on an RF101 vendor list. This is just a place where you can place names and phone numbers, and that simply states, here's a list of names that people can assist you with, and if they don't do a great job, it's not my fault. These are just names that I'm applying to as the source of the source. The term broker across the board is going to be a real estate broker or brokerage firm. The designated agent for the seller is going to be the individual licensee that is appointed by the broker. And in all cases, all agents are a facilitator by default, meaning they don't represent either side. They are defaulted to a facilitator. Now, at some point, they could sign this listing agreement and they could have a buyer's representation agreement signed with another party. And when the two parties come together, that's what's often called as dual agency, where they represent more than one party in a specific transaction. Adverse facts is brought up again, where it simply states that it's a negative impact on the value of the real estate. It significantly reduces the structural integrity, and it presents a health risk to the occupants of the property. If any of these are not disclosed by the seller, and it's generally recognized by a competent licensee, they need to be disclosed. Now, confidentiality is part of your fiduciary duties as a real estate licensee, and so therefore you must zip it and always check with the seller first before you're able to disclose anything. And if you are eligible to disclose anything, like the presence of other offers, Section 18 is where you would place it. Now, B is going to be all of the duties owed to all parties, regardless of an agency agreement signed. This comes straight from the Tennessee Real Estate Brokers License Act. All of these 7 items are also listed on the RF101. And so there's no need to sign the 301 anymore if you're going to go straight into a listing agreement, because the information on 301 is already placed here. It is also copied here into Section C. This is when you sign the listing agreement. These are all the duties that are now owed to this person as the client. That's going to include obeying a lawful instruction, being loyal to their interest, and then scheduling all appointments, receiving offers and counter offers, answering any questions that they might have through the negotiation process, and advising clients on the forms and the procedures to get to the proper closing. Now, this section is where the agent is going to be appointed as a designated agent for this particular transaction. If you're on a team, your team leader's name would also go here, because they're going to have information and access to these documents just like you do. If you have a team where multiple people are going to be in this listing opportunity, you might want to expand this down into your special stipulation block. When in doubt, check with your broker on how they want to do this. Number 2 just talks about the appointment of a subsequent designated agent. That means that the managing broker or the principal broker at any point in time can remove the designated agent listed above and place themselves or another broker into that spot. Okay, this could be another affiliate broker in the office as well. This could happen if the consumer has requested for you to be removed from the transaction, or it also could happen if you were hospitalized, or, goodness, maybe if you were to pass away and somebody else needs to step in. The agreement does not terminate based off of your actions. The brokerage is the one who owns this agreement, and so they will appoint somebody else. Now, this next section is going to talk about defaulting to facilitator in the event both parties are already represented by the same designated agent. It states that you need to disclose to the consumer, to both parties, that you are representing the buyer and you represent the seller, and maybe this buyer wants to see this property. And so upon this disclosure, you're going to go ahead and let them know. And if they say you can move forward, then you're good to go. But upon any default to facilitator status, the former designated agent must assume the neutral position, meaning you're not on either side. You're the door opener and the paper passer. Now, should this offer get ready to be presented and you are in this facilitator status and it goes very well and it goes under contract, but maybe it falls apart during the inspection period. That happens often. If it falls apart in the inspection period, you resume back to your agency status. You don't have to sign another form. You automatically go back to representing just the buyer and representing just the seller. So you can go on about your way, continuing to list the property and get it sold with another buyer and move on with this buyer to a different property. In order to change your status for these things, that would be utilized with the RF303. This is the notification of change in agency status. Next up is going to be the earnest money and trust money. The broker is authorized to accept buyers' deposited money. They also can have this money go into a separate account that is held by a different holder. Oftentimes this is the closing company, the title agency, or an attorney. Typically whoever's closing the transaction, they also can hold the funds. This is called an escrow holder. Now, this earnest money funds does not go to the seller directly. This is not due diligence money. This is earnest money, meaning that it's good faith money that the buyer has placed on the transaction. It's going to be held in escrow until the closing. It could also be dispersed into several other ways should there be a dispute. And we'll talk about those in the purchase and sale agreement. Now, next up is going to be the title. The seller has to transfer good vested marketable title to the buyer. That will be during the title search. So you just want to let the sellers know ahead of time, hey, we're going to do this title search. Do you know of any encumbrances, encroachments, maybe anything that you haven't made payments on? There might be a mechanical lien or something along those lines. Are there any judgments that we need to know about now? That way, it doesn't come up later and become a title issue. The seller also has the option to agree to pay for a home protection plan at the time of the listing. They can also waive it at the time of the listing and negotiate it later in the agreements. There's some other provisions that are going to be listed here that kind of outline the legal terms that are going to be throughout your contracts. Specifically here in this listing agreement, the term for days throughout the agreement is deemed as calendar days, and they end at 11:59 p.m. local time, unless otherwise specified. And local time will be determined by the location of the property. Here in Tennessee, we have some properties in the eastern part of the state in Eastern time, and then we have the rest of the properties in Central Tennessee, and that's going to be Central time. Now you have additional information, whereas if the seller says, I don't want these types of people, or I don't want this type of family in my property, anything that triggers a fair housing violation, you might want to get your broker involved and take a step back. These are legal documents, and you make sure that the consumer understands they are signing legal documents. And again, if there's anything confidential that they want you to disclose, you would place them here in Section 18. Things like you can disclose that there are multiple offers and what the terms are. You might also be able to disclose that their preferred closing date is going to be in March. Anything that they would otherwise need to keep zipped, you can disclose it if it's listed here and they give you authorization. Now, exhibits and addenda are going to be listed here. There's typically not very many that are listed in this section, but if you do need to list it, it's going to be part of the 500 or the 600 series of your forms library, meaning the document would start with the number 5 or it starts with the number 6. Now, there is a special stipulation block, and I want you to be very careful because you're not an attorney and you should not be writing legal verbiage into this section without approval first. So, when in doubt, check with your broker. Most of the brokers have legal counsel that represent firms, and they have a place where they can place office clauses in this section. So when you're utilizing your transaction desk or in the new transact system, you can simply click the block and it will give you an add clause button. When you select the add clause button, your office and system clauses will appear. Now the agent will sign here with the brokerage firm information. Each of the sellers will also sign here. But what happens when you have additional sellers? Well, we're not going to be putting their signature blocks all in the margins. No. Instead, you're going to use the 715. That's the additional signature block for residential agreements. So signature signer 1, signature signer 2, and then 3, and any correlating signatures after that will go on 715. Now you could have this RF101 co-list agreement. This means that there's 2 firms representing this particular property. When this happens, you would have a co-listing agreement that needs to be signed. And in this section, there's a whole compensation block that explains who's getting paid what. The listing broker is going to receive blank, and then the co-listing broker is going to receive blank. And if there's cooperative compensation offered, they will receive blank. The primary firm will do the rest of the paperwork. The secondary co-list firm will just sign this document here. Everybody's disclosed on the confirmation of agency, so there's no question as to which agents are representing whom. That's it for this RF101 Next video, we're going to go deep into the RF141.